Good day, everyone, especially to you, Ma'am Wendelin. I am Mia Tuwalukdol, and our group is to report about Chapter 9 Void and Inexistent Contract. And for my topic, I am to report about Article 1409 and 1410. So, first is let's discuss about Article 1409. So in Article 14.9, the following contracts are inexistent and void from the beginning. So in this article, this discusses about contracts which are void or inexistent from the very beginning. And for number one, this refers to those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. This refers to contracts which cause or object or purpose are against the law, against the morals, against the good customs, against the public order or the public policy. Second is those which are absolutely simulated or fictitious, meaning this refers to contracts that are not real or just imaginary. Next, the third one would be those whose cause or object did not exist at the time of the transaction. This refers to contracts whose cause or object did not exist from the very beginning of the transaction between the parties. The fourth one refers to those whose object is outside the commerce of men, meaning these are referring to contracts whose objects cannot be subject to any contract, such as properties of public dominion, sacred and religious objects. The fifth one, this refers to those who which contemplate an impossible service. So this refers to contracts that contain services that are impossible to do. Next is number six, those where the intention of the parties relative to the principal object of the contract cannot be ascertained. So this refers to contracts which intentions cannot be identified or cannot be sure. Lastly would be the number seven, those expressly prohibited or declared void by law. So this refers to contracts which are in the very first place are declared as void by the law. And these contracts cannot be ratified or cannot be accepted or approved, and neither can the right to set up the defense of illegality be waived or be rejected. Next is that inexistent contracts. This refers to the agreements which lack one or some of all the elements, such as consent, object, and cause, or do not apply with the formalities which are essential for the existence of a contract. So, inexistent contracts, in simple terms, this refers to agreements that are not of the elements that were including consent, object, or cause. Next is that let's discuss about the characteristics of a void contracts. So the characteristics of a void contracts are as follows. First is that generally it produces no effect whatsoever, being void or inexistent from the beginning. So the first characteristic of a void contract uh, refers to contracts that produces no effect whatsoever. Next is that it cannot be cured or validated either by time or ratification. So this refers to contracts that cannot be validated either by time or it cannot be accepted. Next is that the right to set up the defense of illegality, inexistent, or absolute nullity cannot be waived. So it is where you don't have the right to reject or to defend the illegality of the contract, because in the very first place it was already void, or it was already declared as void contract. Next is the fourth characteristic is that the action or defense for the declaration of its illegality, inexistence, or absolute nullity does not prescribe or does not require or does not cannot be claimed or acquired. Next is that the defense of illegality, inexistence, or absolute nullity is not available to third persons whose interests are not directly affected. For number six, it cannot give rise to a valid contract. So, this characteristic of void contracts refers to the one in which it really cannot give rise to a valid contract. It's because in the very first place, it's not considered as valid. And lastly, would be its invalidity can be questioned by affected by it. Next is this, let's distinguish or let's differentiate what void and voidable contracts is. So first is that let's discuss what's voidable. So voidable meaning first is that it may be ratified, or voidable can be accepted or can be approved, while void cannot be ratified or cannot be approved, cannot be accepted. Voidable, it produces effects till annulled. So voidable contracts refers to that it is a contract wherein it can still be in effect, or it still has effect until it was considered as annulled or until it was considered as void, while void contracts generally effects are not produced at all. So in void contracts there are no effect in the very first place. Third is that defect is for voidable, defect is due to incapacity or vitiated consent. So for voidable contracts, it is where the defect is due to the incapacity or vitiated consent or invalidated consent. While for void, the defect here is that the ordinarily public policy is militated against. And the fourth fourth difference is that for voidable, it is valid till annulled, while for void contracts, these are void from the very beginning. So generally, no action is required to set it aside unless the contract has already been performed. Next, for voidable contracts may be cured by prescription, or it may be cured by when the law is requiring it. But for void contract, it cannot be cured by prescription. Next, for voidable, it is where defense may be evoked only by the parties, those principality those principally or subsidiarily liable, or their successors in interest and previce. While for void contracts, their defense may be availed of anybody, whether he is a party to the contract or not, as long as his interest is directly affected. And lastly, for voidable contracts, these referred to as relative or conditional nullity, meaning its nullity or its voidability refers to such condition, while for void contract, it referred to an absolute nullity. So its nullity cannot be changed or cannot be rejected or cannot be approved. Next is that let's go for examples for better understanding. So for number one, those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. So the first one, let's give an example on the one which is contrary to law. So, an agreement whereby Anna is to render service as a servant to Ben without compensation as long as Anna has not paid his debt is reprehensible and censurable. So in this example, it is really contrary to law because Anna don't have the right to not uh, Anna don't have the right not to pay Ben his compensation, even if Ben is indebted to Anna. It is because it is contrary to law, because as what is discussed by law, a person rendering a service must pay for the compensation. Next is this contrary to morals. So, a contract whereby Anna promised to live as the common law wife of Ben without the benefit of marriage in consideration of 50,000 is immoral and therefore void. So, in this example, it is contrary to morals and thereof it is void. Next is this contrary to good customs. So, for example, Anna entered into a contract whereby Anna binds herself to slap his father. So, this contract is void because it is against the good custom of showing respect to our parents. Next is for an example two, contrary to public order. So a stipulation in a contract of lease whereby the landlord can use force to eject the tenant in case of failure of the latter to pay the rent agreed upon is void as being against public order. Next is this example two, contrary to public policy. So, a condition in a contract of sale states that in case of sale, the buyer shall not sell to others the land sold, but only to the seller, or to his heirs or successors for the same price of 5,600 pesos when the latter shall be able to pay it. So, the condition is contrary to public policy because it virtually amounts to a perpetual restriction on the right of ownership, specifically the owner's right to freely dispose of his property. Such a prohibition, indefinite and unlimited as to time, so much so that it shall continue to be applicable even beyond the lifetime of the original parties to the contract is a nullity. Next is for number two, those which are absolutely simulated or fictitious. So we already know that these are referring to contracts which are not real or only imaginary contracts. So like for example, Anna is indebted to Ben. So upon learning that Ben is going to enforce her credit, Anna pretended to sell her land to Philemon, his father-in-law. So Anna did not receive a single centavo for the deed of sale she executed, and she continued in possession of the land as the contract was merely simulated or fictitious. So there is no contract of sale in this case as the parties do not intend to be bound at all. So the sale is but a sham. And for number three, those whose cause or object did not exist at the time of the transaction. So, like for example, Sandra sells to Ben a parcel of land. So, in the deed of sale, 100,000 is stated as the price of the land. So, if this statement is false, then there is no contract of sale. And next is that those whose object is outside the commerce of men. So, like for example, so if the object is outside the commerce of men, such as sidewalks or public plazas or public bridges, they cannot be the object of contracts of alienation, but may be the object, for example, of a contract for repair. And for number five, those which contemplate an impossible service. So in this example, we are to discuss this example. If a blind man enter into a contract which requires the use of his eyesight, so the contract is void. Although in this particular case, we have only a relative impossibility. So this is because here the relative possibility is not merely temporary. And for number 6, those where the intention of the parties relative to the principal object of the contract cannot be ascertained. So, like for example, Anna sold his land to Ben. So, Anna has many lands. So, it cannot be determined which land was intended by the parties to be the subject of the sale. So, therefore, the contract shall be null and void, and it is as if the parties have not entered into any contract at all. And lastly, for number 7, those expressly prohibited or declared void by law. Like, for example, contracts upon future inheritance, except in cases expressly authorized by law. And let's go to Article 1410. So in Article 1410, the action or defense for the declaration of the inexistence of a contract does not prescribe or does not or the law did not require it. So to claim or acquire, that what prescribe means. So if a contract is null and void, the action to declare its existence does not prescribe. So the action cannot be filed anytime. So the mere lapse of time does not validate a void contract. Unlike voidable contracts, if not assailed within the specific period provided by law, shall remain valid. So it if the contract is null and void, then the action to declare its existence is not prescribed or not acquired. It's because in the very first place its existence was void. Next is that a valid contract remains void even if no court has declared its inexistence or illegality. However, there are certain contracts, the nullity of which is not apparent on their faces, like for example the declaration of nullity of marriage. So it must be declared by the court as null and void, otherwise your contract if you contract a subsequent marriage, you will be liable for bigamy. So in here, it states that a valid contract remains void even if the court has declared its inexistence or illegality. And like for example, in this article, in his complaint against B to annul a deed of sale, S alleged that he was surprised to find that the deed was a sale for the document had been represented by B to B for a different purpose. So the action of S based upon the grounds that there is fraud in securing his signature in said deed. So there was no consideration given at the of the transaction. So B raised the defense of prescription, contending that since the action was based on fraud, it should have been brought within 4 years from the time the discovery of the document. So the question is, has S action prescribed? So Supreme Court held no. His action is to declare void and inexistent the deed of sale, which action is imperceptible. And it is according to Incarnation versus Galvan. And that ends my discussion about Article 1409 and Article 1410. Once again, I am Mia Tuwalokdol from Section 2FB.